rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good afternoon. This is the time set for oral argument in our cause number CV130516, Winkler versus BNSF Railway Company. Counsel, we are recording today's proceedings, so when you step to the podium, if you would, please identify yourself and the client you represent. Each side will have 20 minutes for argument, so Mr. Thorpe, you're responsible for watching the clock and reserving any time for rebuttal that you might desire. We've read the briefs. We've conferenced the case prior to argument, so you may want to dispense with a lengthy discussion of procedural history because there is some here. With those preliminaries, Mr. Thorpe, you may proceed.
Thank you, and I would like to reserve 3 minutes for rebuttal. May it please the Court, my name is Bill Thorpe. I represent BNSF Railway Company in this case. As Judge Downey pointed out, this case is a little bit complicated because we have, in essence, 2 very different issues on appeal. The first is a motion for new trial, the appeal from the motion for new trial, and the other is the appeal from the relief from the entry of judgment, the relief from judgment under Rule 60C6.
I know it's rude to interrupt so quickly, but let me focus you on what interests me, which
Sure, of course, Your Honor.
It's all about me. Let's assume for the sake of argument, Judge Fink got it wrong at the outset, that he should have granted summary judgment on the regulatory claim because this wasn't a walkway. Mm-hmm. Tell me, if that were true, what happens after that? What's the effect of that, and why do you get a new trial?
The walkway statute, the presence of the walkway statute in this trial infected the way the entire case was presented because it allowed plaintiff to characterize BNSF as being a complete scofflaw, that it had acted in violation of this regulation that Judge Fink had determined did apply, and he precluded BNSF from introducing certain evidence concerning maybe this isn't a walkway or here are the rules and regulations that apply to maintaining this kind of a track. And it also allowed, but again, it allowed plaintiff from the very beginning, from the 3rd sentence of the opening throughout the case, to characterize this as a case where BNSF was simply ignoring the law. And that had a significant impact on the jury. And it had a significant impact on the way the case was presented.
And I understand this all came up kind of last minute, and everybody did the best they could to sort of salvage the trial and move forward. But why was it not appropriate to let the jury then consider Rule 110 on the issue of negligence?
Because, Your Honor, under Rule 403, that would have been so prejudicial compared to its very limited probative value. There was no way that regulation had any application to the facts of this accident.
Because it wasn't a walkway in your view?
Because it wasn't a walkway and because it was preempted.
And there was a 403 objection?
There was an objection to the admission on a variety of grounds, including prejudice, including relevance, including foundation.
But after Judge Fink dismissed the claim, and I know it was very late in the game, really late, at that point, the railroad did not say to the court, Judge, you need to instruct the jury to disregard everything they've heard about this regulation. And you need to instruct them that it's just out of the case, it's irrelevant, it's immaterial, do not consider it. Railroad didn't make that
You're
request.
right, Your Honor.
Yeah.
We didn't make that, but we initially suggested that it be taken out of evidence, but Judge Fink made clear that at the time this was all happening, that he was not going to take it out of the case, that it had been talked about, it was in the case, and he would not do it if he were asked. So it had been a futile effort.
Okay.
But I certainly agree that that the record would have been better that way.
Then let me go back to a question that either Judge Downey asked you or you were answering. In light of that, given that he said I mean, I understand this was dismissed from the case based on a timing issue.
Correct, Your Honor.
Okay. And so he did not dismiss it based on the walkway point, that this was not, Mr. Winkler was not injured on the walkway. But at that point, shouldn't the railroad have said, Your Honor, there is no foundation, there is no linkage to show that anything relating to walkway standards has any conceivable relevance to the negligence claim, either on standard of care or breach, because they're completely different animals?
Your Honor, that issue had been briefed repeatedly and consistently.
That's the issue you think was futile? It's just,
Yeah, it had been briefed in a summary judgment motion. It had been briefed in a motion for reconsideration. It had been briefed in joint submissions that we had made concerning clarification of his rulings. It had been briefed and briefed and briefed. And if you look at the
Rule 50 motion that you made at the conclusion of plaintiff's case in chief, remind me, as to the regulatory claim, it re-urged the same arguments? Is that correct?
It did, Your Honor. And you know, it was interesting that in the motion in the minute entry denying the new trial, Judge Fink says that this issue has been briefed to death. And that was exactly where we were in the context of the litigation at the point it was removed. And that's why, apparently, Judge Fink felt it was inappropriate to take that out of the case. It had already been admitted over objection into evidence, the text itself. So that's fundamentally the problem. And because it was in evidence, you know, plaintiff, and there was no instruction one way or another on that. If you look at the actual jury instructions, there was nothing about it being evidence of the standard of care or anything like that. There was an answer to a jury question about what do we do with this? It's still in evidence. And he said it is not the law that governs this case, but it is evidence in the negligence case. That was the answer. There was no instruction saying that it was anything. But Judge Fink did not want to remove that from the consideration of the jury because it had already been admitted. So that's where we were. Let me talk for just a minute about the whole walkway statute and why it should never have been in the case, if I could. Because we really feel that was a pretty clear legal error, and that it was a legal error for three reasons that we articulated throughout the proceeding to the trial court. First, as you know factually, this accident happened when Mr. Winkler was stepping down from a locomotive and stepped onto a railroad tie. Under the regulation itself says that walkways are to be adjacent to the tracks, and the tracks include the ties and the rails and the fixtures that affix the rails to the ties and the subgrade. And so he was not on a walkway when he stepped down. He was on the tracks. So that's number one. Number two, this walkway regulation could only be used to establish liability against BNSF if it was it was considered part of a safety statute pursuant to a federal law that simply doesn't apply. It had to be incorporated as a federal safety standard under 54A that we talk about in our brief.
Before we get to preemption, and having looked at the record and the very attractive pictures that we have, and I couldn't find any testimony about this, but perhaps you can help me. If the ties are not part of the walkway, where does the walkway begin? As you're looking at me, to the right of there. At any way,
Oh,
on the other side of the manhole cover?
Somewhere in that range, in that area. Yeah, there's plenty of what there. The issue is simply is there safe passage or a convenient path for the workers to walk alongside the tracks. It's not to be on the tracks.
And the language of the rule, remind me, is adjacent to track, not adjacent to rail.
Correct. And if you look one regulation before that, you'll see that there are specific regulations concerning tracks and ties and the other parts of the rail structure there. So
The rules
plainly,
distinguish 109 and 110. 109 talks about track ballast and walkway ballast and provides, I think, different specifications for the two. Is that an accurate reading?
there are certain specifications for the size of ballast where there's heavily used areas. Yes, Your Honor.
For the most part, I do think the code distinguishes between tracks and walkways, but there's one anomaly in my view. In 110A5, the center of tracks shall be kept clean and free and clear of blah, blah. Why does that belong in a walkway and clearance standard rule?
Frankly, you'll have to ask the Arizona Corporation Commissions, because I've never understood that. I've never understood that either, because you certainly don't want to walk away in the middle of the tracks. And I think that's for places where people will have to cross tracks and they're trying to just keep it clean.
Does it make a difference that Mr. Winkler's heel was, as I recall, partially off the tie when his ankle twisted?
I don't think so, Your Honor, because there's nothing that says that the walkway has to start in the immediate area within,
Is there a jury issue on walkway? Let's say we agree with you partially, but we're not completely convinced that this is a summary judgment issue. Is there a jury issue on walkway under the facts that Mr. Winkler presented?
Your Honor, not under the facts of this case, which is why we repeatedly move for summary judgment. For the reason stated, first, he was on the tracks. He was not in an area that was even contemplated under the statute itself, the regulation itself. And the regulation itself encompasses something that is the subject of extensive federal regulation, which preempts state regulation of track and track structure. And that's the holding of Easterwood and that whole line of preemption cases that we submitted to Your Honor, that establishes that once the FRA has spoken to cover something, that preempts expressly any effort by the state to regulate it. And so there are multiple layers of reasons why this could never have been contemplated as a walkway
So
case.
even if we thought it might be a jury question, it can't be a jury question because it's preempted.
Absolutely preempted, Your Honor. And this is where plaintiff appellee keeps on saying, well, there's no regulations relating to walkways, and that BNSF admits that. Well, what BNSF admits is that there's nothing that says if you want to have a walkway way over there away from the tracks, that's fine, and there's no federal regulation on that, and that's true. But there is federal regulation for every single component of the track, including the track ballast. And there's extensive and pervasive regulation of that at the federal level, and we have supplied that to Your Honors in our appendix. And the case law is absolutely unanimous that action by the Secretary of Transportation through the Federal Railway Administration completely results in federal preemption of the subject matter area.
I know we're all over the map on this, but there are a lot of issues. And so there was some discussion at trial about BNSF having standards that substantially duplicated the administrative code. And I think I read in the answering brief that Mr. Winkler thinks that's somehow significant in potentially saving the jury instruction that allowed the jury to consider the walkway regulation as to negligence. Tell me your view on how that comes into play, if it does, BNSF's regulations.
Well, first of all, BNSF's own internal engineering standards, which is what they would be, do not establish any kind of standard of care here. There was no evidence that they did establish any standard of care that was pertinent or relevant to this location.
But they would as to a walkway. They were somewhat, as I recall, consistent with code provisions regarding walkways.
Well, in the sense that, yes, they said that in certain heavily traveled areas there should be a walkway, yes. But there was nothing that would have implicated in those engineering standards this location or suggested that any walkway in an engineering standard would include a track structure.
Thank you.
But, and forgive me, I'm not as conversant on all the trial testimony, but my understanding is that there was evidence, Mr. Winkler presented evidence to the jury that the railroad had its own internal rules or some standards for walkways, and they were consistent with the state regulation. If that is in fact a state of the record, then can we be so certain that the emphasis on the state regulation tainted the trial? Because it was just consistent with what the railroad said it was going to be doing. So where's the taint?
Your Honor, I simply challenge the record on that, that's what the evidence was, that there was any kind of suggestion that there was a BNSF standard that would suggest that this location where Mr. Winkler stepped off was the subject of a walkway.
Okay, so if there's no such evidence, then that question really is not pertinent.
Okay. That's certainly my view of the evidence, Your Honor, and what my recollection was. Let me turn just briefly to the other issue in this case, which is our appeal from the denial of our 60C6 request for relief from the judgment based on the late disclosed to us information from plaintiff's then wife, Julie Winkler, about the circumstances immediately following this accident and the fact that Mr. Winkler told her that he had, he'd learned about these high Federal Employers Liability Act verdicts and that he didn't feel like he'd really suffered a sufficient injury to really cash in on this situation, and so he had her hit him with the side of an axe, and then when she didn't do it sufficiently hard, he also then hit his own knee against the bedpost on a number of occasions and did so on subsequent occasions, not only immediately after the accident, but over time leading up to trial. Then that was not only verified by her in an affidavit, in testimony that she gave in their divorce proceeding, but also in an affidavit submitted by her mother, who said, A, she had been told that earlier, well before trial in this case, and B, that she had actually seen it when she lived with him, seeing some of the instances of him ramming his knee in an effort to injure it. When we learned about this information, which was about 8-9 months after the judgment, we immediately investigated it. That information came to me in a phone call on December 26th. We immediately investigated it. We found corroborative information concerning police reports, including one just a couple of weeks before the incident that led to this lawsuit. We found police reports concerning problems between the couple that occurred while the case was in trial. We submitted all that, which is all before the panel. And that all seemed to raise a real serious question to us. And we asked this court to revest the trial court, which it did with jurisdiction. And Judge Fink, we believe, simply did not apply the right standard.
Do you want to use the rest of your time on this issue? Because you're running out.
Sounds to me like maybe you think I shouldn't.
Just asking. You can tell from the questions what we're primarily interested in.
Well, I'll leave that issue then as to what it is. We have articulated our view of the standard under 60C6. We don't think he applied the right standard. We think he simply said, well, these go in the first 5 categories, and I'm done. We don't think that's consistent with Amonte. And we've articulated what we believe to be the appropriate standard. And so we're asking either to send it back to Judge Fink with the right standard or to order a new trial based on the evidence that you have before you. With that, I'll sit down and save my last 2 minutes.
Thank you. And Mr. Hale. You've probably been reorganizing your argument as Mr. Thorpe spoke.
Always the challenge. Good afternoon, and may it please the court. I'm Brandon Hale from Osborne Maladon on behalf of appellee Joseph Winkler, who's here with us in the court today. Your Honors, this is a case about a 12-day trial that was presided over by a careful judge, Judge Fink, with what he described as a conscientious jury that was properly instructed without objection from BNSF and rendered a fair and reasonable verdict. And what we have now is BNSF is asking this court for a proverbial second bite at the apple, because it claims that even though the court granted it a directed verdict on Mr. Winkler's walkway claim, it now wants to argue that the walkway evidence of the walkway regulation tainted the trial, and more recently that it's discovered this new evidence that the verdict was allegedly obtained by fraud.
Well, let's just stay with the walkway. I'm sorry, the rule. One can issue for the moment. That rule went all throughout the trial, and the counsel argued over it. It was evidence admitted on how that applies. The trial judge at the end granted the summary judgment, and because that claim isn't proper, that would affect the whole trial, though, correct?
No, Your Honor, I don't think that this court can jump to the conclusion that it did for a couple of reasons. The first reason is that, as we've articulated in the brief, that even if the court had granted the motion for summary judgment, under Arizona law, the walkway regulation would have been admitted as evidence under the standard of care.
Let me interrupt you there, because I
yes.
don't know where in the record we can come to that conclusion as to both foundation and relevance. Let's assume, arguendo, that we don't think that this injury occurred on a walkway as a matter of law. Then evidence of walkway standards, what's the relevance and foundation for walkway standards on something that's not a walkway? I don't see anything in the record. What I do see in the record is if this was a walkway, then arguably, yes, it could come in on the issue of negligence under the line of cases you cite. But I see nothing, including from your expert, who said that even if this was not a walkway, the Rule 110 standards applied, and that would be a hard
Where would we
sell.
look in the record to find that?
Your Honor, what I think if you look, let me start by addressing what the standard is under the pertinent case law, and point to the evidence in the record that satisfies that. The Wendelin case that we cited establishes that a jury can consider regulations as evidence of the standard of care, even if it's not binding on the defendant, under two conditions. There's got to be foundation establishing that the standard at issue is directly related to the exercise of reasonable care, and two, a reasonable nexus exists between the proffered standard and the circumstances of the injury.
And that second prong, under my hypothetical, which is this is not a walkway, is where I don't think you have a record that can support a reasonable nexus between proffered evidence under Rule 110 to a non-walkway site.
Well, and I think what the way I would answer that, Your Honor, is that it's talking about what the standard of care that is implemented by the regulation. And in this case, the standard of care, the simple standard of care articulated in the walkway regulation, is that there be safe footing where railroad employees perform trackside duties.
Well, it's a lot broader than that. You've got a uniform regular surface, which is impossible to have on a track. So it goes much farther. I mean, I don't see any link between all of the commandments of Rule 110 and a track structure.
But again, I think what Your Honor may be missing is that the focus is on what the standard of care that's articulated in the pertinent regulation and where there's a nexus between that standard. And our position, Your Honor, would be that the standard that's articulated in the walkway regulation is a standard of care that's, to me, seems relatively, unremarkable, that where the railroad knows its employees are going to be getting down to perform trackside duties, there should be safe footing for them to do so.
But Mr. Hale, and I appreciate that, but it really doesn't say that. It talks about walkways shall be provided adjacent to tracks in all areas, and goes on. I mean, I know we want to, maybe if you want to take the 30,000-foot view of this, it says that, but looking at what it actually says, it's a little bit different. And that's the point of Judge Downey's question. Where in the record is there evidence of the nexus? Who said it?
Your Honor, and I think this is where the parties and maybe to some extent the court have crossed hairs, and that is where the walkway is at issue in this case. And what I can do that, as we articulated in our answering brief, Mr. Winkler was injured while stepping down in an area of the fuel rack. And Mr. Winkler's contention since day one has been that the area next to the rail ties was problematic, was unsafe. That's always been his contention, and that is the area that's at issue.
He stepped onto a tie, though, and that's indisputably part of the track. Your own expert said that.
But the tie wasn't the problem that was being complained about. The unsafe.
And to the track ballast versus the walkway ballast, which the code clearly distinguishes between. The sizes are different, the dimensions are different, the specifications are different. The track ballast has to be one thing, walkway ballast has to be something else. So, I mean, I think you know where I'm.
As I understand the record, he stepped down, or part of his foot, as he stepped down, part of his foot landed on the cross tie, and then the back of his heel was kind of off of it, and then his ankle rolled in some form or fashion. Okay. But that's all linked to this tie in a very small space. So again, I come back to, and forgive me, where is the nexus or the foundation of the relevance as to the walkway regulation with where he was injured?
The nexus is that the area next to the tie, which under the walkway regulation is a walkway, did not provide safe footing.
So if this is a cross tie and this is the end of it, right here where my finger is the area next, and that's the walkway.
That's exactly right, Your Honor, and I think that's the plain language adjacent to the track, the only interpretation, and then also one of the things that's been talked about in length in the briefing is the appendix, which articulates and demonstrates the location of walkways on mainline track is in fact separate, farther away. But in the yards where this particular incident occurred, that appendix expressly shows that at a very minimum, if it doesn't extend to the rail, at a very minimum, it's right there where the track ends and extends a minimum of 6 feet.
So under the chart or under the appendix, what you're saying here, if I understand it, is that let's talk about the 6 foot minimum. The walkway then would extend from the end, or rather would begin at the end of the cross tie and go out.
At a very minimum, Your
Okay.
Honor.
But the problem I have with your argument based on the appendix is the rule itself only incorporates the measurements and clearances. It doesn't purport to incorporate the pictorial representation, which I think is what you're asking us to read into the rule.
Not necessarily, Your Honor. I think the plain language of the rule, which says adjacent to the track, the term
to
adjacent.
track, not adjacent to rail, which I think is significant here.
Well, so one thing, two responses to that. One is the term track isn't defined, and it's not defined.
An expert said this was part of the track.
The second and more important point is, again, what we're talking about is the walkway beginning immediately adjacent to the rail, which is the area that was always under discussion and was always, that's the footing conditions that were issued. Not the rail tie itself, it's the area next to it.
You've got a good argument to present as to the negligence claim. I just think you're overshooting by claiming that this was a regulatory violation. I get why that happened, but
Your Honor, it brings us to a good point. And that is the second fundamental problem with BNSF's argument that you addressed with Mr. Thorpe, and that is, with respect to this issue about whether or not it should have been admitted as evidence following the directed verdict, the record is clear that BNSF hasn't preserved that issue on appeal. And ultimately, what happened when the directed verdict was entered, Judge Fink did exactly what we want trial judges to do in that situation. He consulted with the parties' counsel. He instructed them as to how he thought it should be dealt with going forward. And it's clear that he thought it could be used as evidence of negligence.
Because he had ruled it was a walkway. But so what you're suggesting is Mr. Thorpe should have said, Judge, this isn't a walkway. I mean, really?
After
How many
all of
times
that?
had the court said it was a walkway? So he was supposed to say, it can't come in because this wasn't a walkway, when Judge Fink had even said very recently in the trial, I've ruled on this many times.
Well, but if you look at the record, there's two things. Immediately when that happened, BNSF did not say, Your Honor, the evidence of the walkway regulation has tainted the trial. You have to instruct the jury to disregard it. In response to Judge Fink's statement, this is what I want to do, Judge Fink couldn't have been more careful and said, is there anything you want to make a record of? And the response was silence. And when he said that the plaintiffs will be allowed to use it as evidence of negligence, BNSF's response was right. And then more importantly, Your Honor, when there was a question from the jury, again, Judge Fink consulted with counsel for both parties. And again, there was no objection to the instruction provided that they could consider it as evidence of negligence.
But then when Mr. Thorpe in his closing tried to argue that this didn't apply because it wasn't a walkway, there was an objection and Judge Fink sustained it. I mean, there were so many levels of complications and I understand your argument about waiver. I just think, and it had honestly some very superficial appeal, but when you consider the fact that Judge Fink had ruled on this issue time and time again, I'm just not sure what saying to that judge, hey, Judge, this wasn't a walkway, so you shouldn't even do that.
I think it's more intricate than that insofar the discussion before, one of the things Mr. Thorpe raised was about prejudice under 403 analysis. That hadn't been briefed. There was nothing along those lines that had been done, and there was no argument with respect to prejudice under Rule 403. I mean, at the end of the day, the record, I think, is clear that Judge Fink gave multiple opportunities to object to that particular instruction, and they didn't.
Judge Fink understand that BSNF believed that the trial on the negligence claim had been tainted by the rule claim. From the record, is it clear that Judge Fink understood, not that he agreed, but that he understood that to be the argument?
Well, and that's the problem, Your Honor, is they didn't do anything to identify for Judge Fink. When they did, in their motion for new trial, when they finally articulate, hey, we think that this tainted the trial, he ruled very clearly that he was impressed with the conscientiousness of the jury, and he also, to address a point Your Honor asked earlier to Mr. Thorpe, he noted the other evidence that was substantial for the negligence claim, and that in fact the walkway regulation adds very little when you think about it. And I would like to address that point very briefly.
Wait, that's a hard sell, because I know you weren't trial counsel, but Rule 110 was front and center throughout the trial, including in the closing argument, and I know you weren't the trial lawyer, who basically said BNSF flouted the law, there's this walkway regulation. I mean, it's a hard sell to say this wasn't that important. That's not the way the case was tried by your predecessor.
What the evidence was at trial, Your Honor, very clearly is that BNSF's own employees uniformly testified that in areas and in this particular location, it's BNSF's practice and their expectation that the ballast be level with the cross ties in order to have safe footing. And
that's great on your negligence claim. That's really good stuff. But it went so far beyond that in the argument of counsel in closing.
I don't think it went beyond that in closing, perhaps in opening, but at the time closing occurred, the court had made its ruling.
That's why it's so bad, because it did go on. Really, I agree with you. It's much more emphasized in opening, but in closing, I don't want to waste your time. Continue, and maybe I'll come back to it. But I have to disagree with you that it wasn't focused on.
What I'll end with, Your Honor, on that issue is simply that the court instructed the jury and answered its question that the walkway regulation was not the law of the case and was only to be used for the evidence of standard of care. And I think the case law supports that this court can't presume that the jury ignored that instruction, and there's no basis to do so. In fact, the jury found Mr. Winkler to have been contributory negligent 20%, which it couldn't have done if the walkway regulation were the law of the case. And so I think, again, Judge Fink, who witnessed the trial, personal observation, the jury is in the best position to make a determination as to whether or not the jury was improperly influenced in any way by this, and he decided it wasn't, and the court
still thought it was a walkway. And you know what? If it was a walkway, then that would be a discretionary call that we'd defer all over to. But if it wasn't a walkway, I don't know how Judge Fink's assessment at that point saves it.
And I'll just go back. I won't reiterate the arguments, but under Wendland and the other case we cited, we think that his instruction that they could consider it as evidence of negligence was absolutely correct, even if it wasn't technically a walkway.
Going back to my concern, I understand the argument about ties and walkways, and when one ends, the other begins. But was there evidence? Evidence, not because. But evidence where someone testified, yes, the walkway begins where the tie ends?
There was, well, I think that's the way Judge Fink viewed it, that was an interpretation.
Putting aside Judge Fink, was there trial evidence before the jury?
Well, I mean, your expert basically said there's a walkway where people walk.
That's right.
That's really helpful.
That's not your legal position, is it?
Our legal position is the position Judge Fink took, which is the interpretation of the statute is a question, at a very minimum, a question of law for the court. To the extent that it was a question of fact for the jury, certainly a reasonable jury could infer that it begins where someone is going to be stepping down. So there's evidence, for example, from Mr. Winkler that the normal course of stepping down from the train, that's where a foot would land. And so I think from that evidence, a jury could conclude that where the foot is naturally going to land is where a walkway begins. I'll briefly address, Your Honors, unless you have no other questions with respect to the merits, I do want to just quickly address the Rule 60 issues.
However you'd like to use your time.
Well, let me address the preemption argument, Tien, to the questions you asked Mr. Thorpe about whether or not there was a jury question there, and as we've articulated in the answering brief, I think there, at a very minimum, there absolutely was. Judge Fink properly concluded that the federal regulation issue doesn't preempt the walkway regulation because the federal regulation didn't substantially subsume the subject matter of the relevant state law. Or the state regulation deals with walkways, with safe footing. The federal regulation is all about the track structure and maintaining safe and secure track structure. And I think the point in Judge Fink's ruling is that those two are not mutually exclusive, and there was no evidence presented in BNSF's motion for summary judgment that the two are mutually exclusive. In other words, what there was no evidence presented in the motion for summary judgment that complying with the walkway standard or regulation would in any ways jeopardize the track structure. And without that, there could be no finding of preemption. There was no evidence presented, so the court was correct in denying the motion for summary judgment. But even if there was some evidence presented, that would have ultimately been a question of fact for the jury to decide whether or not it would actually impact the track structure. I'm out of time, but to summarize, we think it's clear that BNSF received a fair trial that resulted in a reasonable verdict, and for the reasons we've articulated, the court should affirm that verdict. Thank you.
Thank you. And brief rebuttal, Mr. Thorpe?
I have a question.
Although you may not get started because Judge Norris has a question.
But I'll wait till you get to the podium.
Yes, Judge.
Oh, this one
that's
over
right.
here. That's
Sorry.
okay, we all look the same. This is my concern, and it really does relate to what Mr. Hale, our discussion with Mr. Hale about waiver. Once the regulatory claim was out of the case, and I've read the opening and closing and other chunks of the testimony. I mean, that regulatory claim and the walkway and the 110 permeated this case, it seems to me. But once it was really out of the case, at that point, the railroad just did not say, Your Honor, the fact that this claim existed all this time has really tainted everything. I understand your point about that Judge Fink had made up his mind, it's a walkway. That may have been futile. But the fact of the matter, it was the claim that was out of the case. And I don't see anywhere in which an argument was raised. The presence of that claim has tainted. The jury needs to be instructed, disregard the claim. It has no bearing, or even ask for a mistrial. And I'm concerned about the waiver point.
And I understand your concern, Your Honor. First, it would have been futile, and we cited, Your Honor, to the number of times when Judge Fink has said things like, that ship has sailed, that horse is out of the barn, we're done with that. He had said that over and over again, and we put that extensively in our brief. Second, when I started to talk about the issue, he shut me down on it. I was to address this is what it means that it's out of the case.
And that was in your closing argument
Yes.
you're talking about.
And he shut me down after that and told me to move on. So clearly, I mean, Judge Fink understood that we believed that this was a terrible thing for us to be in the case, that they were beating us over the head with it, and it also was going to result, if the jury found that we were in violation of it, it would do away with any comparative fault claim we had. So that he knew that this was a matter of high concern, and that we felt we were being sorely abused by the use of what we felt was a totally preempted, totally inapplicable regulation. And that was clear. This was a long trial. That was very clear.
I know that was Judge Norris's question, but if there was a point you really wanted to make in rebuttal, go ahead,
the last thing I was just going to simply say is, you were asking whether there was some nexus in the evidence about the relationship. Mr. Duffany, their expert, as Judge Downey pointed out, testified that everywhere anybody would walk in this yard was a walkway. So he placed no limits on where the walkway was. It was everywhere. Well, that's almost like saying it's nowhere. And so there was no nexus in the evidence to suggest anything like what they would like you to believe, based on their own expert. Thank you very much.
Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.